This is Bloomberg Law with June Grasso from Bloomberg Radio.
Hunter Biden's defense team rested its case today without his testimony. The week-long trial against President Joe Biden's son was punctuated by dramatic, emotional testimony from his family members and ex-lovers who described his drug-fueled lifestyle when he was in the throes of addiction to crack cocaine from 2015 to 2019. The jury will determine whether Biden is guilty of illegally buying and possessing a gun in mid-October of 2018 when he checked no to a question on a form about whether he was an active, unlawful user of any controlled substance. But defense lawyers argue there's no evidence he was actually using drugs in the 11 days that he possessed the gun and that he didn't knowingly violate the law. The jury deliberated for less than an hour today. Jury deliberations resume tomorrow morning. Joining me is Bloomberg legal reporter Chris Strom, who's covering the trial. So, Chris, what was the main thrust of the prosecution's closing arguments?
The prosecution relied on the evidence that they presented during the trial, which is that a lot of people very close to Hunter Biden, including his ex-lovers, saw him using drugs, knew he was addicted to crack cocaine around the time that he bought the gun, and that there is no doubt about the fact that Hunter filled out the form when he bought the gun that asked him if he was a user of illegal drugs, and he checked the box that said no. And the prosecution says that the evidence is really overwhelming that Hunter Biden broke the law.
Did anyone address the reason why he wanted to buy the gun? Because he never used it.
Correct. It never came up. And part of the reason why it never came up is because Hunter didn't take the stand. I'm sure he would have been asked that question. The defense did not volunteer a reason. The closest they came to offering any explanation was that Hunter Biden was actually in a store across the street from the gun store doing something else, and then he popped into the gun store kind of out of curiosity. The defense tried to imply that it wasn't really an intentional objective for him to go buy the gun so much as he went into the gun store to look around, and then he was kind of convinced by one of the workers at the gun store to buy a gun. But really, the only person who could really speak to why he bought that gun would have been Hunter, but he decided not to take the stand.
So, Chris, the prosecution didn't have anyone who saw him on that day doing drugs or any evidence that on that day he did drugs. How close did they get?
Well, that's correct. The biggest hole in the prosecution's argument is that nobody testified that they saw Hunter using drugs or knew for a fact that he was using drugs on the day he bought the gun or in the days before and after he bought the gun. However, the prosecution did present two text messages indicating that Hunter was trying to buy drugs and was using drugs in the days after he bought the gun. So the day he bought the gun, there's no text messages, but the very next day, he sent a text message saying that he was waiting for a dealer. And the day after that, he sent a text message saying he was laying on a car smoking crack. Now, the defense tried to argue that Hunter was lying when he did that because he was trying to hide from Haley Biden. That's who he had sent the text messages to at that time. And so the defense argued that even though those text messages are real, that they were actually sent, that they weren't true, that Hunter was just making that stuff up.
So as far as the closings, what did the defense concentrate on?
The defense is trying to make the argument that Hunter did not knowingly violate the law, that when he bought the gun, he had a belief that he was getting clean and that he didn't knowingly lie when he said that he is not a user of drugs because in his mind he wasn't using drugs at that time. And so the defense is saying that the prosecution has cherry-picked a lot of different text messages and excerpts from his book to make it sound like he was just on a nonstop drug binge, but they never presented the evidence to back that up, that he was actually, using drugs the day he bought the gun or in the days before and after he bought the gun.
And what exactly did the prosecution say about the time frame that he had to be using drugs?
The prosecution has argued all along that they don't have to serve up direct evidence that Hunter Biden was using drugs on the day he bought the gun, just that they just have to convince the jury beyond a reasonable doubt that Hunter Biden was an addict in the time frame that he bought the gun. What the prosecution is saying is that they can present evidence that Hunter Biden was using drugs as soon as the end of September 2018 and in November 2018. And so from the prosecution's point of view, that is enough of a window of time to say that Hunter Biden, he was addicted to drugs in the October time frame, even though they don't have the specific evidence that Hunter was using drugs in October of 2018, and they don't know exactly what his intent was. There's no piece of evidence where Hunter says, I'm really high and I'm buying a gun right now. There's none of that. But the prosecution says just by virtue of showing that he was definitely using drugs a couple of weeks before he bought the gun and a couple of weeks after he bought the gun. So the prosecution is saying that is sufficient to show that he was addicted to crack cocaine in the time frame that he bought the gun.
So what happened to the defense on Friday? Because Naomi Biden took the stand. I mean, supposedly one of his uncles was going to take the stand, and then all of a sudden the defense said, we have no more witnesses today, and we're going to decide about whether Hunter Biden testifies over the weekend. Do you know what happened to sort of change their trajectory?
What the defense was trying to do blew up in their face. So they brought in Hunter Biden's daughter to testify that she had seen Hunter in August of 2018 and also like a week after he bought the gun. And she testified that he looked really good. He seemed really clear and clean. And so the defense was trying to present her as kind of like a character witness to say that it didn't appear at all to her that Hunter was using drugs. But what happened is that the prosecution had text messages on cross-examination that they presented to Naomi where, especially right after Hunter bought the gun, he was up in New York. And she was texting him, and he wasn't responding, and she didn't know where he was. And she was sending texts like, "Where are you? I can't reach you." And then he finally texted back at like 2 a.m. and said, "Hey, you have my car, and I need to get my car right now." And so the prosecution presented texts that Hunter was sending to Naomi that were suspicious in terms of what was he doing at 2 a.m. where he needed his car so bad, and also that he was ghosting her. And so while the defense wanted to present her as like a character witness, the prosecution was able to show that she actually didn't know what he was doing, and he was acting suspiciously.
It's hard to believe. The defense attorney is so experienced that they didn't look at the text from that time period. It's sort of mind-boggling.
It is. Abby Lowe is known for being a very efficient, good lawyer. He's represented many high-profile clients, including Jared Kushner and Ivanka Trump. The thing is that the defense didn't have a lot of material to work with. There is a lot of evidence about Hunter Biden's drug use in that time frame, and the basic facts aren't in dispute. And if the defense wanted to argue that Hunter didn't knowingly break the law and that he believed that he was clean when he bought the gun, it really kind of required Hunter to take the stand and say that. And without Hunter taking the stand, there's no other evidence to back up what the defense is saying. So we'll see at this point. It's possible that one of the jurors or a couple of the jurors take sympathy on Hunter and they decide not to convict him, even though they might think he's guilty. They might know people who have been addicted to drugs, and they might know what a terrible disease it is, and they might just end up saying that, even though it seems pretty clear that Hunter broke the law, we're not going to convict him, and then we have a hung jury.
Chris, let me ask you this. Was there any testimony about, or did the defense imply in any way that this kind of case normally isn't prosecuted? You know, someone who's addicted to drugs buys a gun but doesn't use the gun in any way and isn't associated with a crime, that those cases are very few and far between that you bring felony charges.
So the defense absolutely presented those arguments in pretrial motions, but they were prohibited by the judge from bringing that information up during the trial. Now, the judge said that this could very well be something that they can bring up on appeal, and so if he's convicted and they appeal it, they can start to raise some of these issues. And the courts have kind of been split recently on whether this kind of a charge is constitutional or not. And so it's a live question right now, but the short answer is that the defense was not allowed to present it to the jury.
Yes, last August, the Fifth Circuit, which is the most conservative circuit in the country, struck down the federal law that bars users of illegal drugs from possessing firearms. And that was a unanimous decision. They cited the landmark Supreme Court decision that changed the framework that lower courts use when analyzing gun restrictions. So the Fifth Circuit's decision is fallout from that 6-3 Supreme Court decision. Of course, the Fifth Circuit decision isn't precedent for Delaware courts. But as you say, if Hunter Biden loses, that would be an appellate issue that he could take to the Third Circuit. Thanks so much, Chris. We'll see if the jury comes down with a decision tomorrow. That's Chris Strom, Bloomberg legal reporter. Coming up next, a historic win for Native American tribes at the Supreme Court. I'm June Grasso, and you're listening to Bloomberg. In a closely divided decision, the Supreme Court ruled for Native American tribes and against the Biden administration on how to divvy up a limited pot of money for tribal health care. The 5-4 decision, written by Chief Justice John Roberts on Thursday, said tribes can sue the federal government to recoup certain administrative expenses associated with running their own health care programs. The unusual alignment joined the Chief Justice with the 3 liberal justices and conservative Neil Gorsuch. Joining me is Andrew Brantingham, a partner at Dorsey Whitney. He's represented Native American tribes in litigation. Andrew, the case centers on the Indian Self-Determination and Education Assistance Act. Tell us about that, what its purpose is.
Great question. So the Indian Self-Determination and Education Assistance Act, which I will call ISDA, as many do in the case law and so forth, was passed in the mid-1970s alongside the Indian Healthcare Improvement Act, which is somewhat relevant to this case. But focusing on the ISDA, right there in the title of the act is the phrase self-determination. And fundamentally what the statute is about giving Indian tribes a level of self-determination in the management and delivery of certain services. Most obviously relevant here is healthcare. So historically, and we're talking, from early in the country's history until the 1970s, the federal government funded and directly managed healthcare services and programs for Native peoples and Indian tribes. And they didn't do very well at it. And not only were the programs chronically underfunded, but they weren't very well managed. IHS, which is the Indian Health Service, is the federal agency that has had this responsibility for a long time. And as things evolved into the 1970s, Congress recognized that they did sort of 2 things to try to improve the situation for funding and management of tribal health care. One is more funding. So that was kind of what IHCIA was about. The other was self-determination. And the concept there is that, along sort of fundamental axiomatic American thinking, we generally assume that people manage themselves better than the government manages them. Organizations, groups, and here Indian tribes, we think can do a better, more efficient job of managing their own programs. So ISDA helps set up a structure in which tribes can choose to manage their own healthcare programs. And the way they do that is they enter into a contract with the federal government, and in that capacity, they act just like a federal contractor. They get the federal funding that IHS would have been using on their behalf, and then the tribes manage that program themselves.
Everyone in the case agreed that the government has to reimburse the tribal-run programs for at least some of the administrative costs. Is the only question whether they had to reimburse administrative costs associated with third-party payers like Medicare and Medicaid and private insurers?
That's basically correct. You've got it. So a little bit of additional context. For a long, long time, and dating at least back to the 70s, and the ISDA has been amended multiple times since then, but for several decades, IHS has collected third-party revenues, which is called program income in the statutes and in the case law. And you're exactly right. The primary source of that is Medicare, Medicaid, and private insurance. And the idea is that, particularly with direct government appropriations being insufficient to cover the cost of these programs, it makes a lot of sense whenever recipients of these services have coverage through Medicare, through private insurance, that IHS should collect that money and use it as supplemental funding. And indeed, the statutes and then the self-determination contracts that these tribes have with the government require the tribes to do the same thing. If they can collect from Medicare for a given service, they're supposed to do that. And then they're supposed to spend that money in furtherance of the healthcare program. And so the tribes are saying, look, you require us to collect and spend these third-party revenues. We therefore also must be reimbursed for the administrative and overhead expenses associated with spending that third-party money.
Is it surprising that the Biden administration was fighting the tribes on that reimbursement?
Well, there's a long tradition, I guess I would say, of the government avoiding making good on these commitments, to be totally honest with you. This case comes in the context of a series of cases in which essentially the Supreme Court has had to tell the federal government that, yes, your promises to Indian tribes are actually enforceable. Most recently, there's a case called Salazar v. Rama Navajo chapter that was from 2012, and that was a case where the federal government essentially said, look, Congress has not appropriated sufficient funds for us to pay all these tribal contractors what the contracts say they should be paid, so we're just going to underpay them. And the Supreme Court said, no, it doesn't work that way. A contract is a contract, and you have to keep your promises, right? So it is unfortunately just axiomatic. It's been the case throughout our history that Congress underfunds tribal health care, and you can feel for the agency and for the federal government actors who have to deal with being underfunded and yet also having these contractual commitments. I guess one would have to say it's not really their fault, but responsibility lies with Congress, but the feds have very often resisted these obligations because it costs more money, and that's the bottom line.
So there was a bit of an unusual alignment of the justices here. The Chief Justice, the three liberals, and Justice Neil Gorsuch, they were the five that voted for the Indian tribes. Tell us about the Chief Justice's majority opinion here.
As I read the decision, I find it to be very straightforward. It's sort of along the lines of what I was just saying. I mean, what he's doing is applying just very typical principles of statutory interpretation and contract law to capture what I think is a very simple proposition. He captures his reasoning. I think one sentence really summed it up toward the end of the majority opinion, where they say, quote, because a self-determination contract requires a tribe to spend program income to further the programs transferred to it in the contract, these provisions of the statute require IHS to pay contract support costs when a tribe does so, just like IHS has to pay support costs when the tribe spends directly appropriated amounts. So I think the chief is looking at this as, look, this is pretty straightforward. It's interesting that you may be familiar with the Indian canon of construction, which is a basic rule of federal common law that says we construe statutes liberally in favor of tribes whenever there's an ambiguity. And that played a role in some of the decisions below and in some of the briefing, but I didn't see that the chief even addressed that here because I think his reasoning just applied the words of the statute.
Right. So it's textualist, right? So the chief is saying that the text of the statute requires this. So then how did the four textualists in the dissent read it? And this comes to the point that textualism doesn't always bring you to the same conclusion. So what did Justice Kavanaugh find?
I would certainly agree with your premise that textualism does not always bring you to the same conclusion. What Justice Kavanaugh wrote was that there were basically 5 reasons why he would agree with the federal government. Some of them had to do with the text of the statute. First, he says, well, the statute doesn't doesn't mention third-party income, which it doesn't use that phrase, of course, but it does address it, as the chief explains. There is also a portion of the statute that says that funds should not be used for contracts that are, I'm paraphrasing here, but that are not sort of directly associated with the self-determination contracts. And the government had leaned on this provision to say, this bars us from paying these costs that are associated with third-party revenue. And again, the majority, I think, dealt with that nicely. Frankly, Justice Kavanaugh also, and I won't go through every argument that he offers here, but I personally think at the end of the day, he leans pretty heavily on the fact that this is going to generate additional costs, which is, of course, not a textualist position. Interestingly, Roberts says that's not really our concern. That's up to Congress. We apply the words of the statute. Interestingly, Kavanaugh sort of says the same thing, but in reverse, and says, it's up to Congress to fix this problem if they're underfunded. And I would respond that they did. The statute does address this.
The agency said that it would cost about $800 million to $200 billion annually, and possibly billions more retroactively to pay the costs here. Does that sound right, or does that sound outlandish?
No one really knows, as far as I can tell. I don't believe that the agency supported that with any real evidence. They sort of just said it. Now, I'm not saying they're making it up. I'm sure there's some reasoning behind it. I think the much more important point to make is the context in which this arises, right? So the additional costs the agency is talking about here are a minuscule drop in the bucket of what America spends on healthcare. We discussed in the amicus brief I submitted in the case, and many others have discussed. For example, a 2018 government study found IHS's per capita spending was about 1/3 of per capita spending by Medicare. Its total spend in 2017 was about $6.68 billion, which is less than 10% of the VA's total annual spend, and about 1% of both Medicare and Medicaid, right? So in this context, my personal view is complaining about, $800 million more is kind of silly. We have in this country a profoundly complex and expensive healthcare funding system, and we have for multiple centuries given Indian tribes the absolute shortest end of the stick when it comes to funding and delivery of services. And so the context matters.
Kavanaugh tried to justify this, I think you referred to this before, by saying that this will divert funding from poorer tribes who can't run their own to richer tribes.
And I mean, that is an argument. You can't get away from the math. It is true that if there is a fixed amount to be divvied up and a certain group gets more, then other groups will get less. The response is it doesn't have to be a fixed amount. It should not be a fixed amount. Congress needs to appropriate more funding to make good on these promises. The court can't solve this problem itself. What the court can do is tell the federal government and everybody else that when you make these commitments, you have to make good on them. And it is up to Congress to come up with additional funding to do that. But I think the notion of sort of wringing our hands over poorer tribes in this dissent doesn't really wash with me. It sort of proceeds from a theory of, all of you are only going to get a certain amount, and so I'm going to try to be more fair about allocating it. But the reality is there needs to be more funding.
Is Justice Neil Gorsuch the conservative justice? He almost always seems to be on the side of the Indian tribes.
That is sort of the received wisdom. Is he is the one people often point to as one who sort of confounds the traditional political assumptions we make about who's going to be on the side of tribes and who is not. And, there's been various commentary out there about why that is. But, he is often seen as the one conservative who is often more amenable to tribal interests than many of the others are.
So, how important is this decision? It didn't get much press because we're talking about healthcare reimbursement. How important is it in the broad scope of Indian tribal rights?
It's very, very important for multiple reasons. You're exactly right. It's kind of technical. It's kind of dry. It doesn't grab people's imagination. But for tribes, it's incredibly important. You got to keep in mind, again, more factual context here, right? IHS itself, massive amounts of its funding are from third-party revenue. IHS fundamentally depends on Medicare and Medicaid and all these other revenues. And so do the tribes that then operate their own programs under self-determination contracts. So we're talking about a very significant aspect of the funding for these programs. Like I said, the overall numbers the government is complaining about, to me, are a drop in the bucket nationwide. But for Indian country, it's a big deal. And for any given tribe, this can mean hundreds of thousands or millions of dollars. There's a wide range of size and expense of tribal programs, but it can mean the difference between being able to operate a program well and having to divert funds from other sources. It's also a super important recognition and way of promoting tribal sovereignty because, again, we come back to where you started with your question about the Self-Determination Act. The notion here is these tribes are getting to manage their own healthcare programs on behalf of their own people in their own best interests according to their own wisdom, right? But when they are not fully funded, and this is discussed in the majority decision, they get what people have called sort of the self-determination penalty because they were having to bear all these administrative costs that they weren't being reimbursed for as compared to IHS, right? So any given tribe that was operating its own program would have less money to spend on direct services because they would have to divert money to pay for overhead. With this decision, that shouldn't happen anymore, and it's at least a step forward in putting tribes on an equal footing with the federal government and allowing them to manage their own programs, which is consistent with the statute, but it's also an important aspect of sovereignty.
Thanks so much for joining us, Andrew. That's Andrew Brantingham, a partner at Dorsey Whitney. Coming up next, Wall Street law firms are invading the booming world of pro sports deals. I'm June Grasso, and you're listening to Bloomberg. Wall Street law firms are muscling into the booming sports deals market, targeting a short list of entrenched law firms that serve billionaire buyers and sellers. The invading law firms are bringing new competition to firms that long ago built specialties in the sales of professional sports franchises and still dominate the work. Joining me is senior Bloomberg Law correspondent Roy Strom. Joining me is Roy Strom, senior correspondent for Bloomberg Law, who's researched the area and written about it. Isn't this a crowded field already?
Yes, there are a good handful of law firms who are very, very well known for representing sports leagues and for representing traditionally the billionaires who buy and sell the teams in the various American sports leagues. And they have a really sort of dominant position in the major transactions when a big team is changing hands. So, yeah, it is crowded in the sense that the firms who have done it for a long time have a very strong position in the market.
And you wrote that there's been a drop in traditional M&A work, so that's sort of also fueled this desire to get into sports?
There has been a drop in the traditional M&A work. The M&A markets that these Wall Street firms like Davis Polk, Cravath, and Wachtell are really best known for advising on have really slowed down over the past couple of years. And so I do think that the sports world has not suffered that same fate. The sports market for M&A deals has been robust, setting records year over year. Bloomberg data shows that in 2023 there was about $25 billion worth of deals in the sports world. And so for a firm that handles major M&A transactions, looking at a deal like the Washington Commanders sale in the NFL valued at over $6 billion, that is certainly something that they are attracted to and they want to be a part of.
I would think that there would be things unique to sports deals that you don't find in other kinds of deals. Is it unique, or is it just the same as any other deal?
It is unique. Transactions involving sports teams are basically under the rules of the specific league. So if you are doing a deal to sell, for example, an NFL team, the NFL has rules around how many investors you can include in your investor group. They have rules around how much debt any given team can carry, and they have rules around how much of a share of the team the controlling owner must possess. And the basic reason for that is because these leagues want 32 people to be able to get in a room and vote on the important things to these leagues. Rules, changes, and other important decisions they make are all made by votes of 32 owners. And so having an understanding of those rules, the lawyers who are in this industry will tell you, is a crucial sort of differentiator that the firms that have been doing these deals for a very long time have, because they really understand those deals. They can quickly tell if it's going to be a non-starter just by running afoul of one of these rules that, as one of the Cravath partners kind of pointed out a little bit jokingly, they are written in English. These are smart people, lawyers who are doing these deals. They can most likely figure them out. But the point of counseling your client to understand and to follow those rules does seem to be a pretty important aspect of this sports deal-making industry.
The incumbent sports deal law firms, there are 5 that remain involved in almost every sports transaction, just 5?
It might be a slightly smaller group than 5, but certainly those.
That's even more amazing.
Yeah, I mean, if you were to make a table listing all the recent deals, looking at the buyers and the sellers and who advised them, these firms like Proskauer Rose, Hogan Lovells, Covington and Burling, DLA Piper, one of them will be involved invariably.
So you talked to Richard Rubano, partner at DLA Piper, and even though there's a specialized aspect, he's been growing his team by hiring lawyers with traditional private equity and M&A backgrounds. Why isn't he looking for the lawyers who have the sports background?
That's right. Well, it goes back to this idea of how different are these transactions really. And the point he made is these deals are more and more, as private equity investors become more involved in this space, these deals are more closely resembling transactions in the sort of traditional private equity M&A world. And he wants lawyers who have that traditional M&A background, who understand what's important in any deal and who know how to manage those deals, sort of a hardcore deal person, for lack of a better term. And he says pretty much we can teach them the 15% that is specific to sports. He says 85% of the deal might be what you're used to in any traditional M&A purchase agreement, but it's the 15% that makes or breaks whether you'll be successful in a sports deal.
And so because of that, I'm surprised that there aren't more lateral moves of these partners familiar with the sports world to firms that are looking to do more sports work.
Yeah, and I think that's something that we might see more of, to be honest with you. But so far, the sports space has been probably less active in terms of lateral hiring than other major practice groups for big law firms. Perhaps the best example of a lateral hire in the sports space was in 2022. Sidley Austin, which is a huge firm, hired the former leaders of the sports practice at O'Melveny and Myers. And these two partners came in. They had a very good reputation in the sports world. And they said that being on the Sidley Austin platform, which has a big European practice and has a really sort of big private equity practice as well, really gave them the sort of leverage to become more involved in the European market, where private equity investing in soccer clubs has just been sort of booming, and it's a more advanced market than the private equity investing in North American clubs. And so shortly after they joined Sidley, they represented a private equity group buying the Premier League's Chelsea Football Club. So that was a big deal for them, and it was indicative probably of what firms can do by adding really well-known, renowned partners in the sports space. And there's really only been a handful of other examples. I know that Latham & Watkins hired a partner at Proskauer Rose who's heavily involved in the sports deal work as well. But yeah, generally the firms that have a grip on the sports work have so far maintained a pretty good grip on the partners that are important to that.
So you spoke to Matt Eisler. You spoke to everyone. I have to say, you spoke to more lawyers for this story. Matt Eisler, who's at Hogan Lovells, and he's longstanding player on major sports team sales, said that our biggest challenge is fighting for an edge to stay on top. As other players get smarter, we become less scarce. And then it's really more about how do we maintain that pole position. If you have these huge players trying to get into the market, it must be difficult to stay on top.
Yeah, I'll say everyone that I spoke with was pretty candid that the amount of competition for these deals is increasing. Nobody sort of buried their head in their sand or said, no, we have no challenger in this space. So it is something that they are all cognizant of. They're all aware of. At the same time, I think they are confident as well that they maintain very deep relationships with the league. Most of these firms really do have their own private equity groups and strong M&A practices. None of these firms are like out of the blue handling these really important sports deals. They are major firms in their own right. And so they are, fighting, and they're maintaining that position best they can.
Fighting in the court, fighting out of the court, and on the court if they have a basketball team. So now, you mentioned private equity a couple of times. What role is private equity playing here?
Private equity plays a few roles, really. In one major way, there's been funds set up. Private equity groups have gone out, raised money with the express purpose of buying what are called minority shares in sports teams. So I mentioned the controlling owner. Somebody might own 70% of an NBA team, but the 30% might be split up between a handful of other owners. And these private equity firms increasingly want to be those minority owners. They want a share of these teams because the valuations are growing so much. The revenue from TV deals just is exploded as live sports programming is really kind of the last bastion of live appointment television. And so private equity investing in these leagues is relatively new. The NFL doesn't even yet allow it. They're supposed to vote to allow it soon, this year. And once that happens, it'll probably be an explosion of NFL teams obtaining private equity investors. And so what's interesting for the law firm side of that is that law firms that have really strong relationships in the private equity world have sort of, through those relationships, gained a foothold in doing these minority share transactions. And one firm in particular, the biggest firm in the country, Kirkland & Ellis, which is probably the biggest private equity firm, has represented one of the most active private equity funds in that space, which just goes to show you that the relationships that those firms are able to develop in the private equity world can carry from sort of industry to industry as those private equity players sort of look to their preferred provider for legal services.
Thanks so much, Roy. That's Roy Strom, Bloomberg Law senior correspondent. And that's it for this edition of the Bloomberg Law podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.